Hello, everyone, and welcome back to another episode of the Military Money Manual podcast. Spencer Reese here from militarymoneymanual.com. Today, we're talking about military medical retirement, which is a topic that I am not very familiar with. So I'm going to learn a lot on this episode. I'm very excited for our two guests today. First of all, we've got Paul, not his real name, but he's going to go by Paul. He's a longtime Military Money Manual listener and sometimes contributor, speaking anonymously today. Following his fourth deployment with the National Guard, he was diagnosed with chronic PTSD and celiac disease. And while eligible for a regular active duty retirement with a 60% longevity multiplier, his state's HR encouraged him not to pursue a medical retirement. He did so anyways and was retired from the Army on permanent disability retired list last summer at 80%, 50% for PTSD and 50% for celiac disease. During the IDES, which is the medical board process, the VA rated him at 100% permanent in total, enabling him to fully retire and support his wife in her new career. He's also working with DFAS on activating his concurrent retirement and disability pay, CRDP, and his break-even for combat-related special compensation, that's CRSC. We're going to hit a lot of acronyms in this episode. I'm excited to get all the definitions of these soon. And that's going to be 40% combat-related for his CRSC. He lives outside of the National Command Region, has several teenagers, and is coming in at the young age of 46 years old. Paul, welcome to the show. Thanks for being here. And I'm going to introduce Joel next as well. Joel Petit is a former Marine Corps judge advocate, Washington, D.C. based attorney specializing in the military disability retirement via the Integrated Disability Evaluation System, or the IDES. He's represented hundreds of service members and veterans from all military services, including the U.S. Coast Guard, and during the pre-IDES process through the post-IDES appeals. Before founding Joel Petit Law, Joel served in the Department of the Navy's TDRL unit at the PEB aboard the Washington Navy Yard. He was a counterintelligence advisor in the IC, the intelligence community, and worked as a healthcare executive at DaVita Kidney Care. Joel holds an MBA from Northwestern's Kellogg School of Management and a JD from Washington University in St. Louis. Joel, welcome to the show. Paul, welcome to the show. Paul, I want to start with your story. So there was a lot happening there in your intro. Why did you decide to go for the medical retirement versus just the standard longevity retirement? And maybe let people know, I think a lot of our listeners are familiar with the standard 20-year military longevity retirement. What is going on with this medical retirement thing?
Hey, thanks, Spencer. And I first want to thank you for sending multiple copies of your book. When we were deployed on my fourth deployment, staff enjoyed them, and hopefully they're working toward being financially free. So the aha moment, and to answer your question for me, it was 6 years ago now during a warfighter exercise. I encountered a reservist captain that I deployed with about 10 years prior. So he was a captain at the time. Actually, he was a PL at the time, platoon leader, who told me that he was retiring from the National Guard with 15 years of total service due to his PTSD, which has been rated over 30%. And this blew my mind because, like you said, Spencer, we're all familiar with the longevity retirement. It's do your 20 and then collect half pay ad infinitum. But here was this captain who had some bad experiences overseas. We were in separate units, and he only had 15 years of service at the time, and he was going to be drawing an immediate medical retirement. So I kind of bookmarked that, knowing that I had more yesterdays than tomorrows in my military career. And what I found in my journey through retirement on expert mode is how I'd characterize it, is that a medical retirement isn't automatically better for everyone. But what it can do is it can accelerate benefits. It can protect part of your retirement income. It can reduce the risk to recall in practice, and it can front load VA and healthcare access in ways that a straight longevity retirement can't. So I've got 7 upsides to medical retirement for me, 5 caveats, and then kind of a why more service members don't know about medical retirement that I can go into whenever you see fit.
Okay, so when you say 7 upsides, this is when you were making the decision, do I take a standard longevity retirement or do I apply for the medical retirement? Is that right?
Yeah, that's exactly right. So because I was eligible for a longevity retirement with over 20 active federal service years, I basically did a course of action analysis on dropping my retirement request, 12, 18 months out, vice obtaining a diagnosis for medical conditions that I had, and requesting a referral into the disability evaluation system from my local military treatment facility. I had to be very proactive about this because there was a institutional hesitancy to refer me into the DES because it's not typically what people want. There's a tremendous amount of uncertainty and, vagueness associated with being, quote, med boarded, which is, what we refer to it in the vernacular, vice just pursuing a standard career. But some upsides for me, and I can go into them at depth. The number one was that I've got a higher retirement multiplier in my back pocket. I was medically retired at 80%, vice my longevity multiplier, which worked out to about 60%. In the event that at some point in the future, CRDP is discontinued. Remember, CRDP exists in federal law under Title 10, but Congress can always amend those laws. And, we've all seen on YouTube the hearings about, supposed veterans fraud concerning benefits. There is a potential future in which CRDP goes away and concurrent receipt goes away. If that happens, I can fall back on that 80% multiplier from my high 3 as a military officer. So that was number one. Number two was I get an early bite at the apple for my VA rating. So when you go through IDES, the Integrated Defense Evaluation System, you're going to have your VA compensation and pension examinations earlier than really anybody else. I mean, BDD, benefits delivery discharge, you would do them on active duty, but you're not necessarily going to get a VA rating before you separate. So when you go through IDES, you get a proposed VA rating while you're still on active duty. And you can dispute that rating, you can appeal it. And I know Joel's going to go into the how, because, we had to do that while you're still on active duty. And that's hugely advantageous if you believe that you deserve a higher rating or if a higher rating is part of your transition plan. So that was number two. The third upside is that it is more difficult to be recalled to active duty. So as a retiree, you remain a member of the Department of War. You can be recalled to active duty. And while formal duty limiting codes, DLCs, don't remain active after you've medically retired, an underlying unfitness determination of medical conditions do stay in your personnel record. So any recall to active duty, especially into your prior job, if you had a especially strenuous or physical job like combat arms, would require a completely new medical qualification and would be significantly harder to implement in practice. So it's a little more difficult for the Department of War to recall you to active duty. Number four, disability premium above a longevity retirement. So what I mean by that, and we'll just use me as an example, I'm an 80% medical retiree from a service, and my longevity multiplier is only 60. Well, that leaves 20% in there. That's not considered divisible marital property. And I'm not an expert on that. I'm not going to go into it. But part of my retirement would be protected against any potential, divorce in the future, God forbid. Number five, and this kind of gets into why more service members don't know about medical retirement. The service member can strongly influence the tempo of his or her transition. There are numerous appeal opportunities, and I know Joel's going to go into this, that really, accelerate or attenuate the pace of your separation or retirement within a window of about 6 to 12 months. The service member being more or less in charge of that process isn't amenable to how the services replace service members. If your service doesn't know when your replacement's showing up because they don't know when you're leaving, that's a problem for them. So I was kind of passively discouraged from pursuing a medical retirement, knowing that I was eligible for a longevity retirement for this reason. Number six, you can get an immediate retired status regardless of years, provided you've met some thresholds. Medical retirement gives you immediate retired pay and benefits, even if you don't have 20 active duty years. This matters especially for Guard and Reserve soldiers and for those broken service careers who may not be able to hit sanctuary or to hit 20, but maybe past 15. And then number seven, you have a family, immediate Tricare retiree eligibility. Chapter 61 retirees get Tricare retired coverage right away. Sure, if you have a VA rating, the VA will take care of you, but what about your dependents? This kind of solves for that problem if you were not eligible for a longevity retirement and you were not otherwise eligible for Tricare retired benefits. So those are seven upsides to the medical retirement process that I encountered, and I'm happy to pause there and expand on any.
I think I want to go back to point number 5 there about the service member dictating the tempo. And I mean, with the institutional kind of hesitancy towards medical retirement and probably just a lack of knowledge of how the system works from a lot of the military treatment facilities, where does a service member start? And like, what kind of conditions or injuries would send someone down kind of this rabbit hole to start exploring their options?
So I am going to answer, but I then want to turn it over to Joel, who has a flow chart that I think answers your question about the opportunities for service members to influence the tempo. So my two conditions that I was referred for were chronic PTSD and celiac disease. Not a lot I could do about either. What I was shocked by once I had been referred was the fact that I had not been previously referred for the chronic PTSD. I had had a diagnosis. I'd been on continuous medication for insomnia, long past the standard for retention. I've been honest and forthright about this during my periodic health examinations. This was all in my service treatment record. I was being treated at military treatment facilities, and yet I had not been referred. So there, like I said earlier, there is a tremendous institutional bias against funneling service members into this process. And I believe it's just a matter of interests. It's not in the service's interest to add uncertainty to the replacement process. And it's not in the service's interest to add a tremendous administrative burden to themselves when they could just kind of let it go. But I want to turn it over to Joel, who could be more specific about the opportunities that exist in the process to, appeal and sort of be an active agent in your own process.
I'll start with starting the process is different for everyone. There are basically three types of DES. I started calling it the DES, so the Disability Evaluation System, because it's dictated by the DoD in DoD Instruction 1332.18. And it's just basically, it's okay, military departments take this generalized instruction and every department can suit it to their needs, so long as it affords service members the rights that are within that instruction. So that's why you see all the processes look a little different, because people wonder, why don't they all look the same? Why can't I take advice from my friend in the Air Force? I'm in the Army. Because they do have the authority to craft it to the way their system or their service is set up, because not all services have the same medical corps, or the medical corps individuals aren't in the same organizations and things. So it's just different. But the reason starting is so different is because, first off, reservists, the injuries, depending on when they're sustained, need to have line of duty investigations done in order to understand whether or not these conditions were incurred on duty, meaning a qualified period of service. And again, that the rabbit hole goes, right? They can be acquired traveling to different types of, it could be drill, so IDT, ADT, that 2 weeks a year if you're a certain type of reservist. And then it gets even more complicated because not all services have the same types of reservists. So this is where everyone gets confused. And on top of that, every service doesn't have the same medical qualifications when it comes to how you get into the DES. So the Air Force and Army have profiles, medical profiles, whereas the Navy Marine Corps simply just has this thing called LIMDU, limited duty. Or I should say you have light duty when you're a little sick, which is the equivalent to like a P2 in the Army. And then you have LIMDU, which is equivalent to a P3, or I should say a T3, a temporary level 3 profile in the Army. And then once you get past your second period of LIMDU in the Navy, that's like getting a permanent 3 in the Army. So this is why I find that when people reach out to people in other services, they get more confused, because it's just these things have nothing to do with the IDES in the process. So people get confused from the very get-go. And that's
right.
Where starting the process, that can actually inhibit how you enter the process and how smooth it is. And not to leave anyone out, the Air Force, they have this thing called Initial Review in lieu of, IRILO for short. It's basically a pre-IDES screening process, so that if they can redesignate an airman, they do that and return that person to duty. So, and that was just changed a few years ago. They used to have appellate rights, just like the IDES. They did away with those because they're like, hey, we don't need to give you these. This is our internal Air Force process. It's not IDES, even though to find out what it is, it's within the Air Force instructions that have to do with the IDES.
Mm-hmm.
So that's confusing. Most airmen think it's part of the IDES, and it's not. So Once you're in the IDES, that's when everything you read in that is that DoD instruction. But of course, in the Navy, it's called the SecNav manual. In the Army, it's AR 635-40. And in the Air Force, it's 36-3212. Those are the manuals, the IDES manuals, or I should say the DES manuals. And I know this is what lawyers are lawyers. Everyone has a different name for the damn system. I was like, why can't we all just call it the DES? And someone says, well, why IDES? It's the Integrated Stability Evaluation System. No, it's not. It can be, under certain circumstances, you can choose the LDES, Legacy, which is just the DoD doing its thing and getting you out. And there's some reasons to do that. Or the vast majority of people go to the IDES. That's where the VA and the DoD work together to get you your VA ratings. And that's what most people know as the DES is the IDES. But then you have this little known thing called the EDES, which is expedited DES for usually death imminent cases. It's help get to close out cases and to make sure families get the benefits that their service member would have gotten. Because if a service member dies on duty, if they're eligible for retirement, the family doesn't necessarily get retirement benefits that they would have otherwise gotten if that person would have been retired. So most people never hear of these things. So, but once you're in that process, the IDES, LDES, or EDES, you have the opportunity to, if there's a problem with your narrative summary that's produced, which is the summary of your potentially unfitting conditions, you have an opportunity to rebut that and to initiate something called an impartial medical review, to have an impartial doctor look over that review or that summary to say, basically, are these medical conclusions accurate? Mm-hmm. And some IMR doctors are more thorough than others. Some will look at other conditions. Others will only say, no, we're limited to these conditions. And then after that, you have an MEB report, which is that first step that goes to be adjudicated. You can rebut that as well. And that has to do with, that can be with line of duty issues. It can be with just any logistical issues. They have the wrong name on a form, which surprisingly happens a lot. So it can be huge issues or it can be small issues. And I think that's what people just don't understand on the very front end, that you can be more involved than you think. The common issue is hurry up and wait, as usual. And then as soon as you get the narrative summary, you typically have 3 days to decide whether you want to do an impartial medical review. And some would say, well, what's the big deal? You sign a piece of paper and they do it. Well, yeah, that's one way to do it. Another way is most attorneys will draft a memo. Again, depending on what service you're in, it could be called a rebuttal, it can be called a memo. But what I tell people is, look, the best way to get lost is not know where you're going. So if you they tell them, hey, I want an IMR. You just tell the doctor, look at this, say if it's kosher, see if it's okay. That doesn't help anybody. If someone says, hey, Joel, here's a case file, tell me what's wrong. That is very inefficient. So imagine if this person is on salary, they're making the same paycheck regardless. That doesn't really incentivize them to help you because you're probably a thorn in their side. So writing a memo or a rebuttal to guide them into, this is the question I have. This is the issue I have with this condition or that condition. You're giving them a roadmap and you're helping that individual help you. Yeah. And that's where I think in the DES process, that's the mindset. That's the healthiest for every service member, is simply, no matter how upset, angry, frustrated you may be, the way that it's set up is you should always be there to help someone help you, because you cannot help yourself, so to speak. You will always be having someone else as a conduit to helping you get you what you want. So you're helping them help you. And if you look at it any other way, it gets very frustrating very quick.
Yeah. So, it just brings to mind, like, no one is going to care about this more than you. So you need to lead the horse to water and then write the memo that says, I want you to drink the water. And you need to take some ownership, which a lot of times in the military, like, we do have that hurry up and wait mentality, or that, well, I'm just waiting for someone else to do something. But it sounds like in this process, the more ownership you take of it and the more you kind of push on the rope and try to get the system to actually do what it's supposed to do, the better outcome you're going to have. And is that kind of where a lawyer comes in to assist you with that?
Yes, that's exactly where an attorney comes in. You got a couple options. You can take the counsel that the service assigns you, or you can obtain private counsel. I initially went with the counsel that the service assigned me. And again, it's just my experience, but as my dad would say, you get what you pay for. So I was in vigorous communication with a counsel out of West Point. She assured me that she had an understanding of my case and that I would need to contact her, the next decision point. When I went to contact her at that next decision point, she had retired. So that's when I tell a little bit about my story, reached out to Joel, which, Joel, I think you had less than a week to put a VA reconsideration review together to take me from 0% for celiac disease all the way up to 50%, which was a huge win and immensely impactful for my family for the rest of my life anyway. You get what you pay for, and I always try to find a professional for a complicated problem like this.
You get what you pay for. Paul, I want to turn it back over to you for the 5 caveats. So if I understand correctly, these are things that someone should be thinking about when they're comparing, hey, do I take the classic longevity retirement if I'm eligible for it, or do I want to go down the road of a medical retirement? And what are those caveats that people should be thinking about?
So, and again, these are just from my experience. I was eligible for that longevity retirement. I was receiving, a recommendation from my HR that no, you should not pursue a medical retirement, but I did anyway. Here's some things to look out for. And the number one would be presumption of fitness. So there's what's called a presumption of fitness rule. If you request a longevity retirement, then your service presumes that you are fit for duty. Now, what that means is, say September 1st, I request retirement for my service effective the following September, right? 12 months out. That's pretty standard. On October 1st, I get diagnosed with an unfitting condition. That may overcome the presumption of fitness. As opposed to if I'm diagnosed with an unfitting condition on August 1st and subsequently request a longevity retirement on September 1st, I may have some more issues and challenges overcoming that presumption of fitness. And that's assuming that I want to be found unfit and I want to be medically retired from the service. I want to pause on that one, the presumption of fitness rule, and turn it over to Joel, and then I'll go through the other 4.
The presumption of fitness is, surprisingly enough, when it comes to for the Army, it is very well spelled out in the AR 635-40 to an extent, meaning it is in black and white, it is in one section, it is not spread out throughout the whole thing like most subjects are in military regulations. But it's one of those things that members, as they get older, or I should say closer to that 20 years, have to realize that the purpose of the IDES is to compensate individuals whose military careers have been ended because of a disability. And that is actually, I think, the exact wording in the presumption of fitness rule, because individuals will say, well, I have this condition. It's chronic. It's been a long time coming. And I'll say, exactly. It's been a long time coming, just like your 20 years has. So how did this end your service? And that is very difficult for most people to explain. And that's why what Paul was saying is generally you're looking at catastrophic events, meaning a new issue happened, such as a car accident, something of that nature, or it could be an existing condition. So let's say you have a mental health condition, let's say it's combat-related PTSD, but you were then carjacked, and it exacerbated that. Well, that can also count and that can also be used to overcome the presumption of fitness. But you also have to go into, how are you performing before this and after this? Meaning this cutoff, depending on which cutoff you're using. But the point is that generally what service members run into is and as we all know this, they were letting me slide on this. I was putting, the S1 or I was the OPSO. So I was telling everyone where to go, doing the logistics, calling this, calling that, but I actually wasn't there doing it. So therefore those standards, I was essentially being not held to certain standards. And of course, to show that means what? Getting people to say, hey, board, I was letting this person slide. So you're basically admitting to being a poor officer. Yeah, that's very hard to come by. And that's why presumption of fitness is such a big deal for a lot of individuals, because unlike other seniorities, if you will, in the military, this is where suddenly you'd think that goodwill would come to save you. In actuality, it's causing everyone to run away like roaches when the lights are turned off. They're not saying we're here to support you and we want to help you. They're saying you're asking me to admit to something that I'm taking an oath not to do, which is not take care of my soldiers, because I'm really not taking care of you, yet I'm having you work when you're injured. It is a very strange, or I should say, it's just counterintuitive to the culture. But logically, it makes complete sense.
And you could see the example of a soldier or airman or Marine who is like, look, like I love being here. I want to keep doing this. And so for that person, they might be, sweeping under the rug. Look, I have this injury, but I'm going to minimize it or not get the care for it that I should be, because I want to stay here and I want to make it, to whatever number it is, 10 years, 12 years, 15, 20 years. And you could have it from both sides, right? Where the institution is saying, look, this is going to be a lot of paperwork. This is going to be really hard. This is going to take a long time. Let's just not do this. And then you might have the institutionalized service member who's saying, yes, exactly. I just want to stay here. I want to keep hanging out with my buddies in the unit. And I want to keep doing my job, right? Because that's why most of us signed up, was to do the work and to serve our country. And so when we get injured, there's a huge, I talk to people all the time and who won't even apply for their VA disability, after 20, 26 years of service. And it's frustrating for me because every time they stand up, their knees crack. And I say, look, man, I'm not a doctor, but I bet you could have a great conversation with a VA examiner about some of the issues you're having. And there's compensation out there available to you. And they can't give you, sometimes there are surgeries, they can give you new knees, but they can't take away your pain, but they can at least, give you some compensation for the injuries and disabilities you sustained while you're on active duty. I can see how, both from the institutional perspective and the service member's perspective, this can be a heavy lift where you have service members who aren't motivated to, go through the medical retirement process. Either A, they don't know about it, B, they don't understand it, or C, they don't want to, quote unquote, let their buddies down, right? There's a huge emotional and psychological stigma, right, about putting up your hand and saying, hey, boss, like, I'm in pain or I'm hurting and I need help. We're just not taught to do that from day one.
Just a quick note from one of our sponsors, and we'll be right back to the show. Hey, Spencer, I've heard about this free Amex Platinum card for military service members. Where can I go to learn more about this?
Great question, Jamie. I've got the Ultimate Military Credit Cards course at militarymoneymanual.com/UMC3. It's a 100% free email-based course, and I explain exactly how to verify your eligibility for credit card annual fee waivers with the Military Lending Act, or MLA, and the Service Member Civil Relief Act, or SCRA. The Ultimate Military Credit Cards course is a beginner's guide to travel hacking and opening up your first annual fee-waived credit card while you or your spouse serves in the U.S. military. There's no spam, no fluff, and the only emails you'll get from me are related to military credit cards. You can unsubscribe at any time, and there's zero cost to you to sign up. You can sign up right now for free at militarymoneymanual.com/UMC3. Again, militarymoneymanual.com/Uniform Mike Charlie 3.
And now back to the show.
The second thing to look out for that really took me by surprise was how quickly this process happens. The service wants this to be done in 180 days. It's actually in the briefing that you give you. Soup to nuts, including my VA reconsideration review that took about 51 days, I was at 9 months. HR told me it was going to take 12 months, and I'd really never know, when I would get out. So you're not really in charge of the timeline, but you can influence it greatly. And the so what of that is you're not going to have the time that you ordinarily would during a BDD claim, benefits delivery discharge, while you're still on active duty, to methodically work with a veteran service officer to populate your VA Form 21-526-EZ. And that's the form where you list all the disabilities that you want the VA to examine you for and consider. So I think I had maybe a week or two to put that thing together. And that presupposed all the research and all the consolidation of medical records and, all the recollection of the conditions that, we just sort of cope with through, in my case, decades of service to put that into the 526EZ. And even then I missed a couple. Didn't end up mattering because I came in at 100% permanent in total. And once that's in, don't touch it. But there are some things in my service treatment record that didn't make it onto that form because I just didn't have the time to work with anybody else. It's a lonely process, for the reasons that you both described. Number 3 is you get what you pay for. Don't cheap out on this process. If you're bewildered and you can't find a subject matter expert at your poster installation, do a Google search, find a reputable counsel, get a free consult, and retain him or her. It's going to pay off. Number 4, a mental health diagnosis may trigger a no weapons profile. So again, kind of going to the stigma of being found unfit and raising your hand and saying, hey, I'm broken. This is a big one, because if you're in a unit where carrying weapons is a usual thing, that's certainly going to be noticed. And no one's going to show up and take your privately owned weapons away. You're not going to automatically lose a security clearance or anything like that. But in some cases, a mental health diagnosis may trigger what's known as a no weapons profile. Yeah, I think we covered the other caveat in the course of the conversation.
I guess, I have so many questions after all this. And I guess one other thing I'll throw out too with the mental health diagnosis is on the Air Force side, right? Like as pilots, that's something that we're always aware of. And if you do want to fly on the outside in the civilian world or continue to fly in the military, right? There's this big stigma around the mental health. And we've got to figure out some way to, the current way the system is set up is as soon as that's on your record, you're basically toast. And that is terrible, right? Because people can't seek the treatment and help they need, and they can't come out the other side and say, hey, like that was a dark period of my life. I never want to go through that again, but I'm good now. And that's just, the way that our system is set up. Anyone in the aviation community is going to say, thanks, but no thanks. We don't want to talk to you. Again, things to consider, things to think about before you start this process. But I don't want that. I say that, then I'm going to turn around and say, I don't want that to deter anybody from doing this process if they need to. But just to be frank, on the aviation side, it could be a career killer, but it might be what you need, what your family needs in order to, in order for you to keep putting food on the table and to keep a roof over their heads. So I think I'll go next with, why don't more people know about this?
It's a matter of systems thinking. So it is in the interest of the Department of War to retain service members. It is not in their interest to maximize their retirement multiplier, and it is not in the Department of War's interest to maximize service members' VA rating for multiple reasons, not limited to a potential increased awareness of the breadth of VA programs for veterans might increase service members' interests in retiring and not staying in. Secondly, who briefs us on our career? HR. And we all have an HR. We all have a different acronym and, an A1, an S1, a G1, whatever it is in your service. The amount of paperwork that a medical retirement is going to create for them, it's ridiculous. And I'll go with PTSD. I'm kind of talking about the GWAT generation here. There is a ton of undiagnosed PTSD and generalized anxiety disorder out there in the force, from decades of war. And all those, that my generation, I'll refer to it, we're also eligible for a longevity retirement. So the easy answer for HR is, hey, you got your 20. Don't you want to know exactly when you're going to get out so you can schedule your party and you can schedule your PCS move and you can tell your next employer when you're going to start? Just go with the longevity retirement. And in my case, that would have been 100% the wrong answer. There were multiple upsides to pursuing a medical retirement, given my diagnoses and my medical conditions. There was a minor cost associated with retaining a private counsel. I had zero regrets.
I think what you said, I don't think there's anything too nefarious happening here. It's just systems respond to incentives and people respond to incentives. And if you have a program that requires a massive amount of paperwork and, doesn't kind of follow the normal process, then people are naturally going to steer away from it. Joel, I was wondering if you could kind of take us through we've touched on it a few times, this IDES process. Most of my listeners will never heard of this. We did have an episode where we talked about benefits delivery on discharge for the VA, but let's talk about this IDES process. Perhaps you can start off with defining it and then kind of taking us through how it works, both from the DoD and the VA side.
Before you get into the IDES process, you have to be referred into it. Okay. And you can only be referred into it, and it's a term of art, so to speak, is that by a medical provider. There is no such thing as a service referral. Some people think there is because they don't see how the sausage is made. It's not. There is always a provider behind the referral. As I was saying earlier, the Air Force has IRILO. That's their pre-screen to retain members, to redesignate them or return them to duty based on their medical outlook. I won't go into that process. It's quite involved. But ironically, in that process, they do produce documents that they will use in the IDES, if you go to the IDES. The Army, they have the profiling system, just like the Air Force, but the Army, simply you need to have a P3 or a P4 in order to be referred into the IDES process. Not a T3, but a P3, so like Papa 3, so permanent. But even then, just because you have a permanent 3 doesn't mean you're automatically referred. You need a second signature. A second doctor needs to basically concur that your referring physician, which is generally your PCM, and who's referring you, even though you may have a specialist helping you, like for diabetes, you have an endocrinologist. They work with your PCM puts in that P3, and then there's a patient admin officer that then will concur, and lo and behold, that's when you can go and get into the IDES. Now, for the Navy Marine Corps, it's a little different. It's a little more laissez-faire. Basically, you have 2 periods of limb due, which is usually 6 months each, and you get into the IDES. Again, I'm oversimplifying because those processes are extremely complex, but just know that it's not taken lightly to get into the IDES, because as Paul said, there's a lot of paperwork and a lot of staffing hours that go into this process.
Real quick testimony on that, and I want to back Joel up. So like I said, I'm seen at a military treatment facility by a medical doctor. Initially, when I brought my 2 referred diagnoses, PTSD and celiac disease, to that doctor told me that my conditions did not meet the standard for referral into DES. I had to go back to my services Army regulation for suitability and quote him how the diagnosis connected to being found unfit. And then after a matter of weeks, I was referred. So there was pushback even at the medical treatment facility level for understandable reasons.
You have that process, which can be daunting for some, less daunting for others, depending on what conditions you have. And then when you're referred into the process, you are detailed a PEBLO, a PEB liaison officer, and PEB stands for Physical Evaluation Board. So Physical Evaluation Board Liaison Officer, PEBLO. And that person, again, I don't know if everyone else says it, but in the Marine Corps, they're like the admin belly button that you press for everything. So they run the show administratively, and they introduce you literally and figuratively to your MSC, your Military Services Coordinator. And most people will know that person is more like a VSO. They're part and parcel the same. One's just working in the IDES. So that's why that person's there. And they help you with, as Paul was saying, the 526CZ. So everyone fills that out. They don't have a special one for IDES, but they also have you fill out an SHA, a Separation Health Assessment, Part Alpha. That is where it's kind of the worksheet, right? To then get all the information to put onto the 526CZ, and a VA 21-0819. That is the form that says, hey, VA, this is an IDES case. Otherwise, it just looks like a 526CZ that someone submitted. But that's nothing special. Basically, looks almost just like the 526CZ with only one with it, but it's a lot shorter, and it simply just has the unfitting conditions. So if you're a soldier and you have 3 P3s that would say, hey, you might be unfit, so they don't meet retention standards, and that's AR 40-501 retention standards. Those will be listed on that sheet. So that's what the MSC does. This is where it gets to be different. That's probably the only thing that's really the same amongst all the systems, or it's clearly the same. Because after that, like I said, in the Air Force, if you've gone through the IRILO, which 99% of people have, you will, that there's a narrative summary drafted. Well, they'll just keep using that. So it's already done before you're even in the IDES. But in the Army, a medical evaluation board doctor, so not your PCM or your treating physician, but a medical board doctor who's hired just to do medical boards, will write the narrative summary. And in the Navy Marine Corps, when I was active duty at Camp Lejeune, that we had an MEB doctor, but that was unheard of anywhere else, and still not always the same in the Navy. Sometimes they have them, sometimes they don't. Some, there are good and there are bad about that, because some would say, well, why not have the person treating this person to write this? And others would say, well, like another doctor would say, how many does that person write?
Yeah.
How good could they be at it if they never do it? So there's pluses and minuses. But the Army is the one that's the best, saying, look, we have MEB doctors, so you know what you're getting. But then after you're in the MEB process, I should say during that, that's all going on. Your command is contacted by the PEBLO to say, we need a functional statement, meaning that's the medical side. Now the functional side. How does this treatment, these conditions, these symptoms, how does it affect this person's ability to complete the duties of their office grade, rank, or rating? And that's just from the DoD instruction. But rating is, for the Navy, but MOS for everyone else, or designation for Navy officers. But the point is, at that point, before they create the MEB report, that means they marry those two things. It's functional and medical, because you can't have that equation without both, because nobody generally cares if you have a diagnosis and it doesn't affect you doing your job, generally speaking. There's a few things like bipolar and a couple other things that are per se unfitting, but very few. And just like if you have a problem doing your job, but you have no medical diagnoses, they call that malingering. You have to have both. And once that's done, of course, like I said, you have the IMR, you can do an MEB rebuttal if you have issues with it. But once the medical board report is done and finalized and you sign off on it, it gets sent to your service's PEB, the Physical Evaluation Board, and the informal board does a records review and adjudicates the case. But of course, all during this whole period, the VA exams, you're going through them, the CMP exams, all that's being compiled. And of course, the medical evaluation board does review that data before they finalize the report, but they're not relying on the VA for their analysis, because what service members need to understand is that when you go into those CMP exams, the doctors will have nothing to do with your records. I mean, they've already reviewed them, or they say they have. They haven't always done so. But if you think you can just say, oh, doc, you haven't seen this newest inpatient mental health treatment I just got out of, here's the documents. They'll say, I don't want them. Like, why are you giving those to me? And that's kind of jarring to most people. They just don't expect it. But very rarely, unless the VA uncovers something that can conflict with your case, do the VA CMP exams, and they produce these things called the disability benefits questionnaires, those DBQs they fill out during the exams, just checklists and whatnot. Very rarely do those upend an IDES case, but sometimes individuals will say things or do things during those exams that the MEB doctor does want to mention. Because sometimes people are, for better or worse, lying during those exams, and the doctors do note it. There's rumors that they watch you as soon as you walk into the building. Sometimes they do, sometimes they don't. But there's little phrases you look out for in those write-ups. If you're bending over to do your forward flexion for your lumbar spine, and it says forward flexion limited by effort, that means you were basically not trying it, right? And you're purposely trying to get things like this, or just like in the mental health arena where they say conversion disorder or functional neurological disorder. That just simply means you're feeling things that don't exist. There's no etiology for this. You're just making them up. And some say, well, I'm not making them up. Well, but that's the point, is you need to know that these things are in your record. That's why reviewing all these things, and they do give them to you, your PEBLO will. You must review them, because once you get to that IPEB stage and they're adjudicated, that will give you insight into why you're being found unfit, or you're being found fit, or maybe they're finding something not in the line of duty, because the IPEB can do that. They can say, yeah, fit, unfit, but we don't agree with this line of duty investigation, and we think it's total bunk, and Like in the Army, HRC, nope, undo that. Like take that off the books. It is not a line of duty. But they don't, mind you, go the other way around. They do not grant lines of duty.
Right.
So it only goes one way, a bad way.
Yeah.
Not that it always does, but they have the power to do that. And then when you're done with that process, you can appeal that process and you can file an IPEB appeal. They call them IPEB reconsiderations in the Navy and Marine Corps, but everyone else calls them IPEB appeals. Well, the Army does, the Air Force. It's actually called something different. But it's not the same as an IPEB appeal. The Air Force is a little special in this case because the CEO of the hospital, generally the convening authority for the MEB, that person would almost, if you will, functionally file an IPEB appeal. And what they're saying is something was wrong medically with this that they didn't catch, or something in the adjudication was wrong. But it's rare to see that in the Air Force. So that's a little different. But after that, you can even have a formal board hearing. And that's a de novo hearing. So it's from scratch. They review everything from scratch. Like the IPEB adjudication didn't even happen. They can rely on that, but they don't have to. And then post FPEB appeal, so even another appeal, that is appeal that's uniform throughout the services, and it's not the same, meaning it's not a de novo review, meaning from scratch, like the FPEB appeal. So you go to the IPEB, you don't like it, you can say, I want an FPEB. Okay, great. No one can say no. Unless but however, if it's not fit at the IPEB, they don't have to grant the FPEB. Very rare to ever do that. They pretty much blanket granted it. But to do a post FPEB appeal, you cannot litigate or relitigate the facts in a case. Meaning, hey, I just disagree with their interpretation of the facts. No. It's usually for fraud, misapplication of law. It can be for, if the decision is, let's say, arbitrary and capricious, meaning they didn't apply the rules fairly. Right. Let's say, for instance, they said, well, it's not clear and convincing evidence. Well, that's not the standard. It's preponderance of the evidence. So that would be a misapplication of law. But you see, it's a legal appeal. It's not a factual appeal, except for new medical evidence. They all say a little differently, except for the Marine Corps, but basically if you have, and it's not just any medical evidence, it's material. So let's say you're on the board, you have, let's just say, Crohn's disease, and you take Humira, so that means you're immunosuppressed, and that's why you can't deploy, and they can't redesignate you, so therefore you're unfit. Well, let's say for some reason they find that you actually get just as good as results from something that doesn't suppress your immune system. Well, now the whole reason you're on the board is gone. That is material new evidence. Basically turns the whole case on its head. I'm trying to make this simple, but it's inordinately complicated, and I understand that. So I have a YouTube video where it took me 9 minutes to run through this as fast as I could, but I wish I could make it simpler. Yeah. But I think the Army handout on this is like 70 or 80 pages.
Yeah, I think that just goes to show the complexity of the matter and why it can, for most people, they're only going to go through this process once, hopefully. And so why not find, it's, that's the same advice I give to people who file their taxes, right? I'm like, hey, you file your taxes once a year. If you hire a CPA, they might have seen 1,000 tax returns in the last year. And just having that additional experience, that additional confidence in what they're doing, just not including all the training, right, and all the education that's gone into how they perform their tax services. Why wouldn't you, for a nominal fee, why wouldn't you hire this person just to take a second look at what you've been doing in H&R Block? And for most military service members, taxes aren't that complex. But from what we've been talking about in this podcast episode so far, I would not want to go through this process without having very good counsel. You actually have a really good, I just pulled it up on your website, the flow chart that Paul was referring to earlier. He's got it pulled up there on the video. But I wanted to just define 3 acronyms that we've been using quite a bit. The PEBLO, the IPEB, and the FPEB. Can you just run through those 3 acronyms real quick for the listener?
So the PEBLO is the PEB, or Physical Evaluation Board Liaison Officer. That person, they are the admin hub for the service member. And for the Air Force, they have, or I should say this, Army, the PEBLO has the most power. They can actually grant and take away leave. or deny leave. The Air Force is not as much power, but they do have, their word is taken very, very, with a lot of gravity. It's just, you want to play nice with those individuals. And in the Navy Marine Corps, they are that admin hub, but they have nothing to do with leave granting or denial, nothing like that. They truly are a conduit. They're very efficient. I would say they're more so than any other service, but it's because they're so laser focused. That's the difference in the PEBLOs. But IPEB is the informal physical evaluation board. That is the first opportunity that someone's case is going to be adjudicated, either fit or unfit. And what service members have to remember is that, well, at least the way I oversimplify it is this: the DoD does one thing and one thing only. You are fit or unfit. That's it. Everything is ancillary. They do combat related. They do. It's not the same thing as a CRC board. It's very different. It's under a different law, so it's not synonyms. However, from fit or unfit, that's when you have all the nuances of the different findings. But in the IDES, they don't rate anybody until you're on the TDRL. So in the first instance, they don't rate you if you're unfit. Once your VA results come back, if it's for your knee, your left knee, they'll say, okay, left knee. If it's one rating, they just cut and paste that onto your findings, or your 356 in the Air Force, or your 199 in the Army, and that's it. So if you think they're doing more, they're not. They're focused on the functional aspect. And the FPEB, the formal physical evaluation board, they are simply the appellate body for the IPEB. And what you have to remember is that the FPEBs are generally made up from the same pool of officers who make up the IPEB. Right. Not your same board. Yeah. But the same pool. So you can have the same members. You can object to that. If you have a member who's the same on both boards, some people want it, some don't, because sometimes you have a kidney issue and you have one nephrologist at the board. You may want that nephrologist on your formal board for whatever reason. But it's not a separate body, and there is no regulation that states it has to be.
Just a quick note from one of our sponsors, and then we'll be right back to the show.
It's no secret Spencer and I are both huge fans of the Thrift Saving Plan, the military's version of the 401k retirement plan. We've both been investing in the TSP for over 14 years and are thrilled to announce we've consolidated all the information you need to know into a new course called the Confident TSP Investing Course.
That's right. The course is a comprehensive guide to navigating the TSP, breaking it down to easy, bite-sized chunks that lay out the basics of the thrift savings plan, the funds available, and the investing strategies so you can build wealth while you serve.
We both know what it's like to be a beginner and to be overwhelmed with all the information that's out there about investing in the TSP. Head over to militarymoneymanual.com/TSP, Tango Sierra Papa, to find our simple breakdown of all you need to know. You get lifetime access, and we'll have a growing library of content. And one of my favorite parts about the course is that for every course we sell, we're going to be donating one to an E4 or below.
Yeah, I love that feature of the course, Jamie. So if you're an officer, an NCO, a senior NCO out there, and you purchase a course, first of all, thank you. And also know that you're helping a fellow service member, a sailor, a soldier, a Marine, an airman, a guardian, a Coast Guardsman, E4 or below, take one step closer to their financial success.
The link's in the show notes, or head over to militarymoneymanual.com/TSP, where you can sign up for the Confident TSP Investing course. Now, back to the show.
Let's talk about VA disability rating. So we mentioned, Paul, in the beginning, 100% permanent and total. And this is something that we talked about on the VA disability episode I did with Doug Nordman. But this is a very common misconception, not just among civilians, but also amongst active duty, Guard, Reserve, veterans. 100% doesn't mean you are bedridden. It doesn't mean that you don't have the use of all four limbs. It's, you could be 100% permanent total and with enough training, go run a marathon. Why? I guess I won't get into why there's this misconception, but what, in your experience going through this process, what would you want to tell another veteran about applying, first of all, about applying for a VA disability rating? And then second of all, if you get rated 100%, what does it actually mean functionally?
I'll give my testimonial, and it's a conversation that I've been having a lot lately as, former colleagues refer me to their friends and so on and so forth, is in the service, it's mission first and people always. And that's a fancy way of saying people second, just to be very, very realist about it. As you approach the end of your career, if you know that is coming, your mission is not necessarily to position yourself for continued service to our great country. That service is coming to a close. Your mission, my mission as a family man, was to ensure that my family would be in the most advantageous position possible with regard to educational benefits, with regard to healthcare, with regard to, a potential future in which I wasn't there due to premature death or worsening of my referred conditions. You got to give yourself permission for that to be okay. Only you are going to do that. We have, the greatest armed forces that, have ever existed in the history of man. It's my privilege to serve alongside the greatest Americans. So part of that is believing in the mission and putting the mission first. It's going to create immense cognitive distress when you flip that switch. And if you don't flip that switch, and if you don't put your family first, if you are a person with a family, which most of us in the service are, whatever that family looks like, they and you are going to pay for it for the rest of your natural life. I don't know how else to put it. I'll just pause there.
Yeah, no, I think well said. I mean, getting the service member, right, to recognize that, no, like you've done your duty, you performed your service, and hopefully that's all been done honorably. And now, to me, I always come back to, look, like when you joined the service, you had to go through MEPs. The government wanted to know what product they were getting, and they recorded it. When you leave the service, you go to your mandatory service medical exam. You are not required to go to a VA compensation and pension exam. And I would love to see the law change and say, look, the government wanted to know what you were when you came in. You have the right when you leave the service, not just the right, but the obligation to know what happened to you while you were on active duty. And for so many service members, for myself in the Air Force, my medical record was 500 pages thick, and that's a pretty small one, right? Compared to some people out there. And in fact, the other day, I dropped it into one of the AI LLMs and said, hey, can you just search through here again? And, here's my VA claim that I filed. Did I miss anything? And sure enough, it went through there and it said, not only did I miss something, but when I went to my VA compensation and pension exam, the examiner said, oh, there was this condition that he mentioned, and I completely forgot about it, but he put it in the letter that I got from the VA and it said, hey, it was noted that the examiner said you might be eligible to apply for this condition, so you should look into it. That was 2 or 3 years ago, and I completely forgot about it. I just went back the other day and filed an update, and so I'm going through the rating process for that again now. But I think for these LLMs, these chatbots are actually, it's going to make the process even simpler for, maybe not simpler, but at least easier for military service members to have a neutral third party review their record and say, look, based on the current schedule of VA disability ratings and based on your medical record, there's probably some things in here that you should go talk to a VSO about.
100%, Spencer. The younger service members, who I talk to, they're all using LLMs, and I'll just say, I know ChatGPT is an OpenAI product. They'll upload their CMP exams, the disability benefit questionnaires, the VA rating decision, and ask to identify gaps, just like you did. And to err is human. Now, what AI won't know is your particular service's proclivities and preferences. What AI won't know is, for example, that you can elect to request an FPEB and later cancel that FPEB, which can impact your timeline. And that's where, private counsel in my case was indispensable. AI is a great tool. It's not an advocate, and it's not a, professionally trained counselor. That's what I'd say.
Trust, but verified. I'd say in this case, don't even trust, especially with some of the errors I've seen.
I pride myself on pulling back the curtain for a lot of people, because that's just what I'm used to doing for educating clients. But when it comes to this subject, it's a structural issue that unless you work in the system, people don't know about it. But I do, just simply because this is why a lot of people quit. Meaning private counsel who are hired by the military's departments to try to do this, is there generally is not a schedule by which the different PEBs publish their rules. They have the manuals that I've noted that I have on my website as well, and they're all over. You can Google them and find them anywhere. Not a problem. It takes 2 seconds. But every board has a president, and they release these memos. And I believe they all are called memos. And they are not simply lighthearted little blurbs about, what preferences are and just timelines. It'll be, we have changed this process that will massively change your case. But they won't tell counsel. They won't tell private counsel. They won't tell even government counsel. They may tell the supervisory counsel at the different services, but that doesn't always get pushed down to the individual counsel who are detailed to service members. So I think what people have to understand is these are not always published publicly. For instance, I recently, I think it was maybe last year, was told during an Air Force case that they had changed the order by which, you apply to it. It's called the SAF-PC, Secretary of the Air Force Personnel Council, when that appeal was going to happen for certain types of cases. And they hadn't told anybody. And they said, oh, by the way, you're going to argue this issue. I'm like, yes, I am. They said, well, you're going to have to do your appeal now. I said, well, why is that? Oh, well, they just released this a few days ago. To who? They didn't give me an answer. They just released it. I don't know, to avoid, I guess, maybe. not avoid, but a void. And it was fine, but it was literally taking an appeal that you would draft after a formal hearing if you needed it. We had to do it before the formal hearing. So it very kind of odd because you're just having the record and proceedings and evidence. So it's very different. But the point is that they don't punish counsel for not knowing because they don't tell anybody. But if your strategy is based on a certain cadence or a certain event happening in a certain order, they do have the power to simply just tell you, we've changed the rules. And so long as it's not contravening the DoD instruction, they can do that. And that's something that AI, LLMs, they just won't know, because unless someone puts it on the internet and then has a commentary or a blog about it, AI won't know what to do with it. And it won't know, because there's no regulation that says they can just publish their own rules. Like it doesn't, there's no regulation that just says that. So that's why it's so difficult to trust and sometimes verify what AI is saying, because the IDES is this weird half gray process.
Hey, Spencer, if I can, I want to go back. I know I covered that fifth caveat in the course of the conversation. Now I'm remembering, what it was. It was be aware of, all the misinformation that's out there about this process. And the reason why I didn't cover that when we were going through the 5 is that we actually covered it before we started taping. So I got it out of the way. And I'm just going to give you one rumor that's out there that is costing time and money, which is if you are 100% P&T from the VA, then your retirement check is tax-free. That is not true. There is no way, no how. And yet this allegation pops up periodically in Facebook groups, in, forums, because maybe we want it to be true. That's just not true. And AI is trained mostly on Reddit. I saw somewhere, a graphic that it's mostly culling Reddit conversations. So garbage in, garbage out. And I don't want to bleed too much into a conversation about VA claims. I listened to your episode with Doug Norman. I read his book. It was outstanding. It definitely influenced my journey. But these separate service processes are so complex and so dynamic and, in some cases, straight up mercurial, that you got to have wise counsel. It's not your PEBLO, and it's probably not your assigned counsel.
We'll just keep hammering on that. I mean, this, like I said, this is not something anybody's going to go through more than once in life. So if I was going through this process, which thankfully I didn't have to, I just separated and went through the VA disability process.
On that note, with PEBLO, when it comes to PEBLOs, you'll hear a lot of people bemoan PEBLOs, meaning that they don't reach out enough. They're good, they're bad. It's like any profession, right? You have high flyers, and you have people at the bottom of the barrel. It is what it is. But the worst thing someone can do with a PEBLO is say, well, what would you do in my situation? Because that person, that's first off, I say worst, I don't mean because a PEBLO is a no. What I'm saying is that's not their job, and they are not allowed to tell you. They're not allowed to give you counsel. So when service members do that, they're putting the PEBLO in a very tough position, because usually they are sympathetic and they'll feel bad that maybe they didn't get out through disability, and they're just like, this sucks that this happened to this person and they're so injured and I want to help them. But if they answer that question, they can unknowingly, right, as they say, the road to hell is paved with good intentions. They can easily lead someone down that path without knowing it. But also, again, people will say, I've heard lots of people say, well, why does it matter? They're just telling about a deadline or a time frame, that's their job. And I'll say, yes, but if you don't think that filing for something at a certain point can affect your legal rights, you are wrong, because I have cases every year where someone has told somebody, you have a great option here, except move on. And when my client comes back and tells me about what they did, I usually will say, okay, did you consider X, Y, or Z? We talked about all this. Why did you do this? And they said I was in a great position. I said, but why did they say that? Or what did they base that on? And it was just enthusiasm for the member, being done with their IDES process, that stress, the worry. I'm like, it wasn't based on, was it good for you? It was based on I would say, the good for you. Like, good for you being done, but no, it's good for you. And in every year, there's usually someone who accepts something they shouldn't have because they were caught up in getting everything done with and wrapped up, and not realizing that there was more to do, or there was a benefit in waiting. And there's lots of, let's just say, nuances to different processes within the different services. So they're all different, that can affect when you do these things. So if you think that just signing a piece of paper, even though you've maxed everything out, is just signing a piece of paper, you're wrong. Because again, certain services have slowly implemented rules that don't exist. Meaning, for instance, members have to follow up on what they submit. That is not true. That's why you have a PEBLO, because there's no rule that the member has no one else to reach out to. So they use the PEBLOs to make sure that things are submitted on time. But if something doesn't get submitted, a lot of times people will say, well, why didn't you follow up? And my answer to that is, show me where it says they have to do that. And if they do follow up, show me who has to say yes or no, they didn't get this, or they got this. But they don't have that rule. So that's why they don't have a rule you have to follow up, because there's no one to say yes or no. And it gets inordinately complex. And this is why asking your PEBLO for advice it's bad for them. It could easily turn to be into a situation that's bad for you. And you want to make sure that whether it's government or private counsel, that you just make sure that you're taking everything into consideration, especially at the end of the process, because you're at the end of that long, usually arduous road, and you want to make sure it ends well.
And in addition, Joel, I had a fantastic PEBLO, professional, experienced, definitely kept me on track. What's the PEBLO's job? The PEBLO's job is to get you done. That's what the service cares about. It's right in it's actually 80 slides, Joel. Earlier you said it was a 80 slide briefing that they give to families. Their goal is to complete this process in 6 months. Those 6 months account for 0 appeals. None. That's soup to nuts. So the PEBLO's job is to get you done and to move on. They got a caseload like any other officer. It's not to ensure the best possible outcome. And like Joel said, it might be in your interest to prolong this process.
Okay. There is so much in here, and I feel like we could keep going on this topic. Joel, I'm sure you've got some YouTube videos for people who need to learn more about this. The 2 topics I want to cover before we wrap up, and feel free, guys, to throw out other topics that you want to cover before we wrap up here, is financial consequences medical retirement, longevity retirement, VA compensation, how that all interacts, considerations for family. And then, so that's the first topic, the money. And then number two is what you want to warn others about and what you want to leave. If a listener is listening to this and they're listening to this episode for a specific reason, right? Because they're considering, I might be eligible for a medical board, or maybe they've only served a year or two, but they've been in the suck out in Syria and Iraq, or maybe they've served 25 years and it's all just kind of adding up, and they're thinking, hey, it's about time I threw in the towel. Topic number two would be, what do you want to warn that specific listener about, and what do you want to leave them with for next action steps? So number one, let's talk about the money, financial consequences.
So financial consequences, it does matter what component you're in. So I regularly preach this, that I believe, well, I know that the rules are a little wonky when it comes to reservists for medical retirement, because usually reservists get the short end of the stick for everything. That's just how the reserves do it. But for the medical retirement, it is the opposite. I believe someone was not understanding the way reservist time is calculated, because when a reservist is medically retired, let's say that person is at 05 with 22 years in. When they're retired, let's say 70%. Well, the high 3 pay that they use for that retiree at that moment is the current high 3. So that makes sense. However, the years of service, it is not the reservist calculation of points divided by 360 equals the years of service. No, it is simply good years. So that does make a difference. And what people fail to appreciate is, I've had several of these clients where when you have a senior officer who has a high disability percentage, that person can easily, through their disability retirement, make more than if they were to simply throw in the towel and say, you know what, waive the board, I'm retirement eligible, and I'm going to go for my longevity retirement. Because at that point, that person's longevity retirement, as we all know, is based on their longevity points calculation, which is points divided by 360 equals years of service. So there are massive financial consequences for individuals who are senior, or I would say senior officers, just at certain pay levels and certain disability percentages. When they're retired and they're reservists, they can actually do better through medical retirement and obviate the need to ever submit for longevity retirement, because for the reserves, you have to submit to receive your CRDP. So some of my clients will never have to exercise that option, even though they have their 20-year letter, but the math says they would be insane to do so. And that's something that does not exist for the active duty CRDP, concurrent receipt, unless they are going through CRSC or some other program, is always infinitely more lucrative than a medical retirement. So it's the opposite for some reserve members. And doing those calculations is usually not, well, there is no one to do them. No one at DFAS will do them for you. This is where you just, for me, I do them for my clients because I have a finance background as well. So that's why I do CRSC calculations and things like that. But most individuals who have the wherewithal to understand the legal side don't have the wherewithal to understand the financial side. And that is I'd say the biggest takeaway when it comes to the money piece, that is especially for a active duty individual, it is, I would be hard pressed to ever find a situation where your concurrent receipt scenario does not vastly outweigh your medical retirement scenario. Whereas reservists, that is not the case.
So Joel, for the listener who might be thinking about this, or really, like when I tell people like, hey, everybody leaves the military in some way, shape, or form. So when, people are talking about documenting your injuries and documenting your medical care, I mean, that should just be basic hygiene stuff. That should be it for everybody. But what would you warn someone who's going through this process or is thinking about starting this process?
I would say that the number one focus would be, don't let the process just simply play out, because there's too many interested parties, so to speak, not to be a conspiracy theorist, that they're not looking out for your best interests because they have a process to complete. They have that 180-day timeline to meet. And if yours is a case that's an outlier, they'll do everything they can to shorten it, because it will be briefed to eventually individuals at the Pentagon, not necessarily your name and everything like that, but you will start skewing the numbers in the wrong way. And so just as an example of one interest that will start to negatively impact or could negatively impact your case. So when you're an active participant, you're reviewing things, and it could be things that are just deathly boring to you. Maybe not to me, because that's my profession, but for most people, they're mind numbing. But if you're not engaged, you can quickly find yourself with a mounting list of issues to address and not enough mechanisms by which to address them. And you basically get behind the 8 ball, and you are forced to take whatever they hand to you, because sadly enough, if you're a junior member and if you do not have the resources to hire private counsel, the government counsel, especially when it comes to the Army and the Navy Marine Corps, those programs have been gutted for various reasons and issues of counsel. So it's very hard to get an attorney to analyze your case within 7 or 10 days of your hearing happening for your FPEB. And it's very difficult even to get into contact with IPEB counsel. And IPEB counsel aren't individually assigned. So I was increasingly frustrated when I was in the government, because I knew what these cases needed. And when I had 5 to 6 days to help somebody, that was just, gut-wrenching, when I knew that they could have been taken care of easily if someone would have talked to them 6 months ago at the IPEB level. But no one did. And at that point, when I said, I need you to go see a neurologist, and they said, it takes 30 days to get into that person. Well, guess what? Seeking new evidence is not a reason for delay in any case, in any forum. So guess what? You're up the creek without a paddle. And that is, I would say, the biggest worry that I have for people who either won't or can't be proactive in the process, because you don't get a second bite at the apple. And to come back to the Board of Correction for Naval Records, or the Air Force or Army Board of Correction for Military Records, it takes 2 to 3 years of processing, and it costs a lot of money, and it takes a lot of work to undo these issues. So being an active participant in your case is, I would say, the number one thing you can do to help yourself. And of course, there's a laundry list of others, but that is I would say, the most available thing people can do. Because no matter how much money you have, be it a lot or a little, no one is going to say you cannot review your records and you cannot be a participant in your case. So it's a strategy. It's available to everyone.
Paul, anything that on the financial consequences or what you want to warn others about, what you would say to a fellow service member if they're thinking about starting this process?
One thing I didn't mention was the cost of healthcare. So, and I didn't find this out until I was retired under Chapter 61, is that my Tricare premium for my family, which, right now I've got 3 teenagers and a spouse. In 10 years, I'm just going to have a spouse. My annual premium is frozen for life. And I plan on living a really long time. I got a World War II vet grandfather. He's turning 100 this year. He was in the Army Air Corps, which I know my Air Force brothers love it when I bring that up, the Army Air Corps. And I'm going to be paying less than $700 a year for the rest of my life for healthcare. And that wouldn't be the case if I was a longevity retiree. So that's a big one. And we don't know how big that one's going to be. Number two, for me anyway, there was no windfall associated with being a medical retiree. And I really want to keep the VA rating separate from this. The services have it figured out to where if your medical multiplier, and mine was 80%, exceeds your longevity multiplier, and mine was about 60%, and you want CRDP, so you want to get that second check every month, you're going to be getting your longevity multiplier. Like Joel said earlier, it makes financial sense. Okay. So it's going to be a wash, but on DFAS's side, they're going to see that you are a Chapter 61 medical retiree, and you'll have the continuing benefits associated with that. So the reduced health insurance costs annually, that was the big win. And there's some other little stuff out there. And then the caveat is fear is the mind killer. This is a bewildering process. No one in your unit is going to be intimately familiar with it, because to be intimately familiar with it, you either have to have gone through it or be a trained professional in it. And while, all of us will separate and retire from service, it's a minority of a minority of a minority that are going to medically retire from the service. So seek expert help and choose yourself. It's going to feel wrong. You're going to feel it in your heart because you were a good service member. But now's the time in your career. You got to do it. You got to gather your medical evidence. You got to understand the process, get a good counsel on your side, and choose yourself. Put your family first.
I think that's a great way to wrap it up. Paul, thank you so much for sharing your personal story. I know for a lot of these things, like it can be tough to go open kimono and talk about what you've gone through, but it's extremely valuable for both people who have gone through the process and are looking for someone to relate to, but also for anybody who is considering a medical retirement or is being pushed that way, just to understand like what's about to happen. And I think that, Joel, your expertise in this matter was greatly appreciated as well. I want to leave the listener with any resources, Joel or Paul, that you can recommend where they can go learn more about this. Joel, feel free to pitch your law firm as well.
I would say that having been a Marine Corps' first active duty IDES attorney, I was a guinea pig. I think I'm the only person who's done every level of DES advisory, and every client I've ever talked to, be active duty, reserve, when I was government, whatever, every person's confused. So if you're feeling confused, you're not alone. You are the majority. But every person, I spent at least the first 10 or 15 minutes explaining everything to them, the broad strokes and in their case. So my website, just maybe 6 months ago, added a resources page for this very reason, because I don't know why it's so impossible for the services to just have everything that they offer just on one website. So I just broke it into DOD, then Naval Marine Corps, Air Force, and then Army, and the Coast Guard. They are still finalizing their IDES program. So it's actually they haven't even published anything, which is to the chagrin of most Coasties. But that is where I point most of any of my people who email me, call me. I'll tell them, hey, go to the resources page here. What I'm talking about, you can find it here under this tab, that tab, because things like the CRSC guidance from the DoD, most individuals don't know it exists. They don't even understand where these rules come from. I try slowly to add resources there, and I only add the things that I know are very pertinent. So I wish I could point people to another CRSC website or something like that, but I can't because they don't exist. And when it comes to the IDES, the best thing people can do is when they get the handouts from their services is to read through them and try to just understand what the nuances are. But again, on my website, I have on the PEB portion, I have a flow chart that I just created for myself because that's what helped me learn when I started. So when I created my website, that's what I started doing. All the flow charts I have on there, I drew them for me at one point. And I said, what? This is public information. I'm not hiding it. Like I'm not giving anything away. It's all out there. So I just did what, for some reason, the military departments refused to buy a MS Visio subscription and just do a wire diagram. So that's what I did.
Right.
And so I did that just because, honestly, clients who are more informed are better clients. And people who aren't clients, it'll help them too. So why not? And I just think it's a shame that it's like pummeling people with handouts isn't the answer. It's not quantity, it's quality. We all know that pictures, they're the saying, a picture is worth 1,000 words, exists for a reason. So why every service doesn't have just a flip book of pictures, I don't know, because you could do it.
I totally relate with that because, I mean, that's how my website got started was I was trying to understand the TSP, trying to understand these credit card benefits, trying to understand all the other, military money stuff and they would just throw these, 10 or 20 page documents at us. And I'd be like, okay, but like, what do I actually do with this? Like how can I take this very complex topic and distill it down to what do you actually need to do as a service member? So I really appreciate that you've taken the time to build those diagrams. And, that's how my site started was I'm just trying to understand this myself. And then once I've done the work, why not just share it with the rest of, the military community for free? If that brings me a client to my military money mentor program, excellent. If 100 people use it for free and benefit themselves, even better.
Not everyone needs an attorney. And I tell, people every day, look, don't hire me. You don't need me because you're dealing with this issue. And so you don't know what's that issue. And all they needed was someone to tell them the issue. So they don't need an attorney. And so, for a lot of people who don't need attorneys, that's kind of who I want to be using that because you don't want to create a market from people who don't need the service. Because then it gives us as practitioners a bad reputation of tricking people into needing a service they don't need. And that shouldn't be how it is. It should be, it's value for value. And that's it. And if you can't offer value, I don't want you as a colleague. And you shouldn't be helping military members who can't afford to throw money away on someone who's not offering something of value. And that's why I tell everyone, hiring an attorney, I don't care who they are, in what capacity, it's an investment. So it's what's your ROI on that investment? And if you don't see it that way, you're not looking at it the right way because you'll then end up hiring the wrong person.
Paul, Joel, thank you both so very much. We'll have lots and lots of resources to share in the show notes so people can find that on Apple, Spotify, wherever they get their podcasts. We will make sure that we get this out to as many of our listeners as we can. Thank you both so much for taking the time. This might be our longest episode ever, nearly 2 hours. So lots of great information, very densely packed. And I'm sure some people who need this information will go back and listen again. But thank you both very much.
Thanks, Spencer. It was a pleasure.
Thanks so much for tuning in to this episode of the Military Money Manual podcast. If you're enjoying the show, please feel free to rate, subscribe, and leave a review wherever you listen to your podcasts. This helps others find the show, and we really appreciate it. Thanks again for tuning in, and we'll catch you in the next episode.
The views and opinions presented here are those of the speakers and do not necessarily represent the views of the DoD or its components. Reference to any commercial products or services does not constitute DoD endorsement of those products or services.